Imagine a world where every single click, every purchase, yeah, even just casually browsing online, it all adds up. It builds this invisible digital profile of who you are.
Mm-hmm. Profile that can be, you know, bought, sold, used in ways you probably never intended.
Exactly. So is that just the price we pay for convenience? Or is it maybe a fundamental threat to our autonomy in this digital age?
It's a huge question.
It really is, because this isn't just about what you buy online. It goes deeper. It's about your basic information rights, the ideas you create even, and how society tries or maybe fails to govern this borderless digital world.
Yeah.
E-commerce doesn't just happen, it's engineered, seriously. From the business models, the cybersecurity, the whole digital economy, it runs on strategic thinking, complex systems, and, well, the people who know how to build and manage them.
That's right. It's built piece by piece.
So in this deep dive, we're not just looking at the how of e-business, we're digging into the crucial should we questions and asking what are the real consequences down the line.
The ethical layer.
Exactly. And this deep dive, it's specifically tailored for students of BCIS 5379, the Technology of E-Business, at Tarleton State University's Dr. Sam Pack College of Business. Our mission today really is to give you the insights you need to navigate this really complex ethical, social, and political landscape of e-commerce. We want to make sure you can, identify, analyze, and strategically respond to these critical issues in your future e-business work.
Which are core skills for the field.
Absolutely. And hey, before we unpack all this, if you're finding these insights valuable, and we hope you do, please take just a second to like this deep dive, subscribe to the channel, maybe share it with your classmates or colleagues.
Yeah, that really helps us out.
It does. Your engagement helps us bring these kinds of discussions, these insider tips, to more future leaders like you. Helps position everyone for a brighter future in whatever career they choose. And remember, check the description below for additional resources. We'll link to things that go even deeper.
Okay, so today we're pulling back the curtain, really getting into the critical ethical, social, and political dimensions that honestly underpin the entire e-commerce ecosystem.
Yeah, the foundations.
Exactly. We're drawing mainly from Chapter 8 of E-commerce 2023, Business Technology Society by Laudon and Traver. We'll explore 4 major dimensions: information rights, property rights, governance, and public safety and welfare.
That's a lot to cover.
It is, but it's all connected. We'll break down core ethical principles, look into the, let's say, nuanced world of privacy and intellectual property, and discuss how the internet is governed. Or maybe how it isn't really governed.
Yeah, that's a good point.
And all with practical takeaways for you as future business and tech professionals. Specifically, by the end of this deep dive, you'll be better equipped to relate to these legal, ethical, social, and political issues that e-commerce raises. And you'll be able to critically evaluate these into your own e-business solutions, which, are key knowledge and skills outcomes for BCIS 5379.
Okay, so we've set the stage, this massive digital footprint we're all creating. It's kind of overwhelming. How do we even start to navigate this digital wild west of data?
Yeah, where's the map?
Exactly. So our first point here, the ethical compass of e-commerce makes us look at the foundations, the bedrock principles that ideally should guide every single decision we make online. It's easy to just think of e-commerce as, buying and selling stuff online. Simple. But its very nature, the technology itself, creates these distinct ethical, social, political implications that often just get overlooked.
They really do. Because the tech isn't neutral.
Not at all. Think about it. Traditional business, you had pretty clear boundaries, right? You walked into a store, bought something, left. Online. Those lines are completely blurred. Gone. The technology itself throws up a whole new set of challenges, like tech ubiquity, the internet's everywhere, always on.
24/7.
Right. Which blurs the lines between work life, home life. It can increase consumer work time, make personal boundary just incredibly porous. You're always kind of on call, always reachable.
That always-on culture definitely has downsides.
It does. Then there's global reach. E-commerce doesn't care about national borders.
Nope. Click, and you're international.
Sounds amazing for business, doesn't it? But boom, instantly complicates legal jurisdiction. What's totally fine, legally, ethically, in one country, say, certain types of online gambling or maybe specific content
could be completely illegal or taboo somewhere else.
Exactly. Imagine trying to run a business navigating that legal minefield. It's tough.
It's incredibly complex, and the universal standards of the internet, they're sort of a double-edged sword too.
How so?
Well, on one hand, they lower entry costs for businesses, Makes it easier for new players, new ideas to emerge. That's great.
Yeah, democratization almost.
Kind of. But on the other hand, those same universal standards make global monitoring and information collection much, much simpler.
Easier to watch, everyone.
Pretty much. And this ease of data capture leads us straight into information richness. We're talking about the sheer amount of detailed, extensive data that can be collected online. And this isn't just about, what you type into a form. It's sophisticated profiling, sometimes even surveillance, often happening without you really knowing the full extent or giving truly comprehensive consent.
Which is pretty intense when you layer on the next feature, interactivity. We like engaging with brands, with other users online, right? It feels dynamic.
Yeah, part of the appeal.
But that interactivity also allows for continuous monitoring of user behavior.
Yeah.
Every click, every time your mouse hovers over something, how long you stay on a page.
It's all data points.
Exactly. And that ties right into information density. The cost of collecting, storing, processing all this information, it's plummeted.
Moore's Law in action,
Yeah.
basically. Cheaper storage, faster processing.
Right. So companies can now aggregate massive amounts of data about you, about me, about everyone, and that just fuels huge privacy concerns.
And all that dense information, combined with these other features, allows for intense personalization and customization. Which can be good, right?
Yeah.
Getting recommendations you actually like.
It can be fantastic, yeah. Seeing products you genuinely might want, content that resonates, but it completely relies on deep data collection.
There's the catch.
There's the catch. And this can lead to subtle but really significant issues. Things like price discrimination, showing different prices to different people for the exact same thing based on what the algorithm thinks you'll pay.
Yeah, I've heard of that.
And just further privacy intrusions. So these inherent characteristics of e-commerce, they fundamentally change the ethical landscape compared to, the old brick and mortar world.
It's a massive shift, paradigm shift, really. And these issues, they don't just float around in space. They operate on, 3 interconnected levels. Laudon and Traver have this figure 8.1. It's like a ripple effect.
Explain that. Okay, so at the core, the smallest ripple, you have the individual. That's where you face ethical dilemmas, personal choices, right versus wrong actions. What do I do?
My own decisions.
Right. But then, when lots of individuals make similar choices, that starts to shape the next ripple out. Societal choices. That's where we, as a society, decide what's acceptable, what's not. It reflects our collective values.
Okay, the social norms.
Exactly. And then the biggest ripple. Those social choices, those norms, they eventually push for policy changes. That leads to the formal stuff laws, regulations enforced by political systems.
So individual actions can eventually lead to laws?
Yeah, potentially. Think about something like sharing copyrighted music back in the day. Individual choices influenced social acceptance, or lack thereof, which eventually led to new digital copyright laws like the DMCA. It's a chain reaction.
That's a powerful framework, laying out that individual-to-policy ripple effect. But isn't there a lag? Doesn't policy sometimes seem to lag so far behind the technology that individuals in society are kind of left floundering without clear rules for ages?
Oh, absolutely. It feels like policy is always playing catch-up, doesn't it? The tech moves at lightning speed, the laws take years.
Right.
And that's precisely why, to even begin understanding these dilemmas, we need to go back to basics. The bedrock. Basic ethical concepts.
The fundamentals.
Right. Ethics, simply put, it's the study of principles. Principles individuals and organizations use to figure out right and wrong courses of action. It's not just a gut feeling, it's supposed to be a systematic approach.
And there are some core ideas that underpin most ethical thinking.
Exactly. 4 foundational principles, really. First, there's responsibility. The idea that as free moral agents, individuals, organizations, even whole societies, we are accountable for the actions we take.
You'll own your actions.
You own your actions, and not just your intent, but the consequences. Second, building on that is accountability, which means you can actually be held to others for those consequences. You have to answer for what you did.
Okay, so responsibility is owning it, accountability is answering for it.
You got it. Third is liability. Now, this is more of a feature of political systems, of the law. This is where laws actually permit individuals to recover damages money, usually from others because of their actions. It's the legal recourse when responsibility and accountability fail.
The legal teeth.
Right. And finally, due process. This is crucial. It ensures that laws are known, they're understood, and they're applied correctly, fairly. And importantly, that you have a way to appeal to a higher authority if you think the law wasn't applied right.
Got it. Responsibility, accountability, liability, due process. Seems straightforward enough.
Seems like it, but
Uh, but the insight here, especially for e-commerce, is how easily technology can fracture these principles, right?
exactly.
Think about a big data breach. Who is truly responsible? You've got maybe complex algorithms involved, third-party vendors, human errors scattered across different teams, maybe different countries.
It's a mess to untangle.
A total mess.
Yeah.
And then how do you hold any single entity accountable in this borderless digital space?
Yeah.
It's incredibly difficult. So that's where these principles stop being, just abstract philosophy and become critically practical for anyone planning an e-business.
So for the students listening, the takeaway is?
The takeaway is these aren't just things to know for a test. They are the fundamental guardrails for responsible innovation. Ignoring them, that can lead to huge legal costs, serious damage to your reputation, and honestly, it could sink your whole business eventually.
Okay, so if those principles are the map, how do we actually use the map when we hit one of those ethical roadblocks? You mentioned a structured approach. Can you walk us through how an e-business student might actually apply that in a, real-world sticky situation?
Absolutely. Because you will face ethical dilemmas in your career. It's not if, it's when. And just reacting based on gut feeling isn't enough. There's a structured 5-step model for analysis drawing from Laudon and Traver that can really guide you.
Okay, step 1.
Step 1. Identify the facts. Sounds basic, right? But often, initial reports are confusing or incomplete. Who did what? Where? When? How? Just getting the details straight is crucial. Often, simply clarifying the facts can resolve some of the initial confusion or disagreement. Everyone needs to be on the same page about what actually happened.
Makes sense. Get the story straight first. Step 2.
Step 2. Define the conflict or dilemma. What are the higher-order values clashing here? Is it freedom of speech versus protecting minors? Is it the company's need for profit versus customer privacy? Understanding the core values and tension is key to figuring out what's really at stake.
Okay, finding the core tensions. Step 3.
Step 3. Identify the stakeholders. Who has an interest in how this turns out? It's usually more than just the company and the customer. Think about regulators, employees, shareholders, maybe business partners, the wider community.
Everyone affected.
Everyone affected. And what do they want? What are their stakes in this situation? Knowing this is vital if you want to find a solution that considers or at least acknowledges all the different perspectives.
Okay, stakeholders. Step 4.
Step 4. Identify reasonable options. And notice the word reasonable. It's really important to accept that a perfect solution, one that makes everyone happy and has no downsides, probably doesn't exist.
Yeah, it rarely does.
Right. So often you're looking for the best possible course of action among several imperfect choices. Some options will clearly be better, more ethical, more sustainable than others, even if they involve trade-offs.
Okay, finding the least worst option sometimes.
Sometimes, yeah. Or the most balanced one. And finally, step 5, identify potential consequences. For each of those reasonable options you identified, what happens next? Evaluate both the short-term impacts and the long-term ones.
Thinking ahead.
Thinking way ahead. And a good rule of thumb here is to ask yourself, what if we did this consistently? What if this became our standard practice? Would that lead to a sustainable, ethical outcome over time? Or would it create bigger problems down the road?
Okay, let's make this concrete. Quick example.
Sure, let's take that scenario you mentioned. A company develops a really effective AI tool for personalized ads. Super profitable.
Okay.
But it achieves this by collecting deeply personal user data, maybe inferred data, without getting explicit granular consent for every type of data it uses.
Okay, facts are clear. Powerful data collection, fuzzy consent, dilemma.
Dilemma is pretty clearly privacy versus profit, or maybe customer trust versus rapid business growth.
Stakeholders.
Customers, obviously. Company shareholders wanting profit.
Right.
The AI developers who built it. Potentially regulators like the FTC. Maybe even competitors.
Options.
Options could range from 1, just keep doing it, hope nobody notices or complains too loudly. 2, implement a really clear, robust opt-in system explaining exactly what data is used and how, even if it hurts conversion rates. 3, maybe redesign the AI to be less invasive, using less sensitive data. Or 4, stop using that specific tool altogether.
And consequences for each.
Option 1, short-term profit? Maybe. But huge long-term risk loss of trust. Massive fines if caught. Brand damage. Option 2, might hurt short-term profits, but builds long-term trust and legal compliance. Option 3, might be technically challenging, maybe less effective advertising, but a good middle ground. Option 4, safest ethically, but loses the competitive edge.
Okay, I see how that structured approach Forces you to think it through methodically.
Yeah.
Helps move past just the gut reaction.
Exactly. It leads to a more reasoned, defensible decision. And that's critical for developing a professional e-business proposal, one of the key writing outcomes for your course. You need to show you've considered these angles.
Right. Now, beyond that analytical framework, you also mentioned there are specific ethical principles that can guide decisions, helping companies build trust and go beyond just, ticking the legal boxes.
Yes, there are 8 principles commonly cited that offer different perspectives. First, and probably most famous, is the golden rule. Do unto others as you would have them do unto you.
Treat people how you want to be treated. Simple.
Simple, but powerful. It forces empathy. Would you be okay if this was done to you? Second, universalism. This asks, if an action isn't right for all situations, is it right for any situation? It's kind of like Kant's categorical imperative, a societal survival test. Could society function or thrive if everyone always acted this way?
Okay. That's a high bar. What's next?
Third, the slippery slope principle. It's a warning. If an action can't be taken repeatedly without negative consequences, then maybe don't take it even once. Be careful about those small, incremental, ethical compromises that can lead you down a really bad path you can't easily get back from.
Like boiling a frog, slowly.
Kind of, yeah. Fourth is the collective utilitarian principle. Take the action that achieves the greatest value for all of society. This isn't just about maximizing your company's profit. It's a broader cost-benefit analysis for the common good.
Okay, the greater good. That sounds related to the fifth one.
It is related. The fifth is risk aversion. Take the action that produces the least harm or potential cost. Focus on minimizing the negative impact, the downside, the unintended consequences. Especially important when dealing with potentially vulnerable populations or irreversible actions.
Okay, minimize harm. Sixth.
Sixth principle, no free lunch. This assumes that virtually all tangible and intangible objects are owned by someone unless there's a specific declaration otherwise. It emphasizes ownership, giving credit where it's due, and compensating people for their intellectual effort or property.
Now, that one seems like a potential flashpoint in the digital economy, doesn't it? We hear about data being the new oil, often just harvested freely. How does that square with no free lunch? Is our personal data owned by us?
That's an excellent point, and yes, it's absolutely a key battleground. When you think about how much personal data is collected, analyzed, monetized, often without any direct compensation to the individual, or even clear, informed consent covering all uses, it directly challenges this no free lunch idea. It raises fundamental questions about data ownership in the digital age. Who really owns your clickstream?
Yeah, huge questions there. Okay, what's the seventh principle?
The seventh is the New York Times test, sometimes called the perfect information rule. Basically, assume your decision and all the reasoning behind it is going to be published on the front page of the New York Times tomorrow morning.
Ooh, the public scrutiny test.
Exactly. How would the public react? Would you be proud or embarrassed? It encourages transparency and thinking about how your actions look from the outside.
That's a good gut check. And the last one.
And finally, number 8 is the social contract rule. This asks you to consider, would you want to live in a society where the ethical principle behind your action was the organizing principle for everyone? It forces a deeper self-reflection on the kind of world your choices are helping to create.
Wow. Okay, so those 8 principles, golden rule, universalism, slippery slope, utilitarianism, risk aversion, no free lunch, NYT test, and social contract, they really offer a robust toolkit.
They do. They help you evaluate your e-business decisions beyond just, is this legal? They push towards, is this right? Is this responsible? Is this sustainable? And using these thoughtfully is critical for developing that professional e-business proposal that considers the broader societal impact hitting that key writing outcome for the course. It helps differentiate your ideas as being both innovative and responsible.
Okay, let's pivot now. Let's zoom in on one of the absolute most pressing issues in this whole digital realm, privacy and information rights, navigating the digital footprint. It's everywhere in the news. It affects everyone. But what is privacy, really, in this digital age?
It's a slippery concept these days. The traditional definition, is that privacy is the moral right of individuals to be left alone, to be free from surveillance or interference by others, individuals, companies, even the government.
The right to be let alone.
Right. But the internet adds so many layers of complexity. So we also talk about information privacy. This refers more specifically to the claim that, 1, certain information just shouldn't be collected at all, and 2, that individuals should have control over the use of whatever information is collected about them.
Control. That seems key.
It's central to the debate. And a concept that's really gained traction, especially over in Europe, is the right to be forgotten.
Ah, yes, the GDPR buzzword.
Exactly. The idea is that individuals should be able to access their personal information held by websites, edit it, change it, or even delete it entirely. Europe, particularly with its general data protection regulation, the GDPR, is definitely leading the charge here. Their stance is much stronger than what we typically see in the U.S.
You know, I'm fascinated by this right to be forgotten. On one level, it sounds incredibly empowering, right? A
Mm.
chance to wipe the slate clean, erase that embarrassing old blog post or whatever.
A digital reset.
Yeah. But then, almost immediately, my mind goes to the potential downsides, the unintended consequences. What are some of the major risks or, ethical pitfalls that pop up when people start trying to erase their digital past?
That's a critical question, absolutely.
Yeah.
Because while the benefits are obvious, like you said, removing inaccurate data, irrelevant old stuff,
Hmm.
things that just don't define you anymore, the risks are pretty substantial too.
Like what?
Well, what if criminals try to use it to hide their past convictions? Or, politicians trying to scrub records of misconduct? Then there's the public interest argument. Don't we have a right to know certain things about public figures?
Right, history matters.
History matters.
Mm.
So it creates this really difficult clash.
Yeah.
How do you balance this individual right to be forgotten with other fundamental rights like freedom of speech or the need for historical record keeping or public safety?
Yeah, there are no easy answers there at all. It's a real balancing act.
A very tough one. And historically, if you look at how the concept of privacy developed, it took quite different paths in the public versus the private sector.
That was so.
In the public sector dealing with government intrusion, the fight for privacy rights has a really long history. Goes back centuries, involves lots of court rulings, laws. In the U.S., you can trace roots to the Bill of Rights. Figures like Warren and Brandeis, who wrote that famous article in 1890 about the right to be let alone.
Right, worried about new technologies even back then.
Exactly. Brandeis, in his dissent in the Olmstead wiretapping case, basically predicted how technology could become a tool for government surveillance, far more effective than stretching upon the rack, as he put it. We also have international agreements like the Universal Declaration of Human Rights, the ICCPR. They all address public sector privacy.
Okay, so a long history with government. What about companies?
Privacy in the private sector, dealing with corporations collecting your data. That's a much more recent phenomena. It's largely still in flux, constantly evolving, and it's been almost entirely fueled by the internet and its incredible capacity for data collection. E-commerce really put these private sector privacy issues front and center.
So the rules for Google are different from the rules for the government, basically.
Largely, yes. The legal frameworks and societal expectations around what the government can collect versus what a company can collect are still developing and, in many ways, quite distinct.
Okay, so if our digital footprint is constantly being, well, engineered, as we said.
Whacked out.
Mapped out, yeah. Then the question isn't just how they track us, but who owns the map. And that takes us right back to this very personal idea of privacy and information rights. What exactly are the big threats to our individual privacy coming from e-commerce?
Well, at the heart of it is something called personally identifiable information, or PII.
PII, heard that acronym.
Yeah, you hear it a lot. It's basically any data that can be used to directly identify you, locate you, or contact you. So your name, address, email, phone number. But it can also include things like your social security number, maybe even sensitive medical conditions linked to your name.
Okay, the obvious stuff.
The obvious stuff. But it goes way beyond that. Companies also collect vast amounts of anonymous information. This is demographic data like age range, location, plus behavioral info, what sites you visit, what you click on, but without direct identifiers attached.
Okay, so that's safer.
Safer, maybe, but here's where it gets tricky. That anonymous data is often used for profiling. That means creating these digital images, these portraits, that characterize your online behavior and the behavior of groups you seem to belong to.
Digital profiles.
Exactly. Now, you can have anonymous profiles, which basically identify people as belonging to very specific targeted groups, like males aged 25-34 interested in hiking gear in Colorado, without actually naming them.
Okay. Still feels a bit creepy, but anonymous.
Right. But then you get personal profiles. And that's where they take that behavioral data, that anonymous profile, and they manage to link PII to it. Maybe your email address captured from a login or your phone number from an app permission. Suddenly, that detailed picture of your interests and behaviors has your name attached.
And that's where the real privacy risk blows up.
That's where it gets significantly more concerning for most people.
So how are they gathering all this info? What are the tools in their toolbox? It feels like it's constantly evolving.
It absolutely is. Think of it like a technological arms race, constantly escalating. We started with the basics. Cookies.
Ah, the infamous cookie.
The infamous cookie, just small text files stored in your browser, tracking your browsing behavior across sites, mostly used for targeted advertising back then. Relatively simple.
We all learned to delete those, though.
We did. So as users got savvier, the industry developed more covert tools, things like web beacons, sometimes called web bugs, or tracking pixels.
Tiny, invisible things.
Yeah. Exactly. Often just a one-by-one pixel transparent graphic embedded on a web page or in an email. You don't see them, but when your browser loads them, it sends a signal back to a server logging that you accessed the page or opened the email. They act like digital tripwires, tracking you without you even realizing it.
Sneaky. What came after that?
Well, when even those became somewhat manageable for really privacy-conscious folks, the industry moved towards more persistent methods. We saw the rise of Flash cookies, though Flash is mostly dead now, thankfully. These were stored outside the browser's normal cookie controls, making them much harder to find and delete.
Okay, more persistent.
And then things got really sophisticated with techniques like device fingerprinting. This is clever and kind of scary. It identifies your specific device, your computer, your phone, based on its unique combination of hardware and software configurations. Things like your browser type and version, your operating system, screen resolution, installed fonts, plugins, all collected without needing to store any file like a cookie on your device.
Wow. So deleting cookies doesn't stop that.
Nope. It's much harder for an average user to block device fingerprinting. And then the big one now is this whole world of cross-site tracking, cross-device tracking, and cross-device graphs.
Okay, break that down.
This is where companies track your activity not just on one site, but across many different websites and apps you use. And even more powerfully, they connect your activity across all your different devices, your laptop at work, your phone on the commute, your tablet at home. They build these complex graphs to link all these signals back to you, a single individual.
Creating one giant profile from everywhere.
Exactly. A truly comprehensive, unified profile of your entire digital life. The real insight here is this constant cat and mouse game. Users try to protect privacy, the industry develops more sophisticated tracking, users find new tools, industry adapts again. It's relentless.
This intricate web, it feels like almost every single thing you do online contributes to this massive digital picture of you. So the big question becomes, how do we protect ourselves? What are the guardrails? Are there any? Legal, technological?
Right.
What's out there?
It's a mixed bag, especially in the United States. Legally, the landscape is quite fragmented. Unlike Europe, we don't have a single comprehensive federal privacy law that covers everything.
No GDPR equivalent here.
Not really, no. Instead, privacy protection often relies on specific court cases that establish what counts as a reasonable expectation of privacy. Or it comes through laws that target specific sectors, like H.Schuessler, the Health Insurance Portability and Accountability Act, which protects your medical records.
Right, doctors can't just share your info.
Exactly. Or COPO, the Children's Online Privacy Protection Act. This is really important. It safeguards data collected online from children under the age of 13. It requires websites and apps to get verifiable parental consent before collecting kids' data.
But only up to 13. What about teenagers?
That's a major criticism, yeah. COPO offers strong protections for younger kids, but it leaves teenagers 13, 17 in a sort of gray area with fewer specific federal protections online. It's a patchwork approach. Definitely leaves gaps.
Okay, so sector-specific laws. Who enforces this stuff?
The main federal agency involved is the Federal Trade Commission, the FTC. They play a really crucial role. They conduct research on privacy issues, they recommend legislation to Congress, they sue companies for unfair or deceptive practices related to data collection, and generally try to promote market function and increase consumer choice.
So they have some teeth.
They do, yes. And they've developed these really influential Fair Information Practice Principles, or FIPS. Even though they're not fully codified into one single law, they form the bedrock of much U.S. privacy thinking.
What are the FIPS?
There are 5 core principles. First, notice awareness. Companies should tell you what data they collect and how they use it before they collect it. Transparency.
Okay.
Second, choice consent. You, the consumer, should have a choice about how your information is used, especially for secondary uses beyond what's necessary for the transaction.
Let me choose.
Third, access participation. You should be able to see the data collected about you and correct it if it's wrong.
See my data.
Fourth, security. Companies need to take reasonable steps to protect the data they collect from misuse, loss, or unauthorized access.
Keep it safe.
And fifth, enforcement. There needs to be a mechanism in place to actually enforce these principles to make sure companies comply.
Notice choice, access, security, enforcement. Okay.
Those FIPS are foundational.
Now, that choice consent one, I hear terms like opt-in and opt-out. What's the difference there? It seems important.
Hugely important difference. With an opt-in model, the company needs your explicit affirmative permission before they can collect or use your data for certain purposes. The default setting is no collection. You have to actively say yes.
So I have to check the box.
To tick the box, click the button, whatever. It puts the control firmly with the consumer. An opt-out model is the opposite. The company assumes they have your permission by default. They collect and use your data unless you take specific action to tell them not to, like finding some buried setting and unchecking a pre-checked box.
Which is way less protective for the user.
Way less protective. Most privacy advocates strongly favor opt-in, while many businesses prefer opt-out because it results in more data collection.
Makes sense. Now, you said there's no big federal law, but what about states? I hear a lot about California.
Yes, California has definitely been leading the way at the state level with the California Consumer Privacy Act, or CCPA, which went into effect in 2020, building on a 2018 law. It's quite comprehensive.
What does it give Californians?
It grants California residents several key rights. The right to know what personal data is being collected about them, the right to know if their data is being sold or disclosed, and to whom, the right to say no to the sale of their personal information, opt out, the right to access their personal data, the right to request that a business delete their personal information, and the right not to be discriminated against for exercising these privacy rights.
That sounds pretty strong. Does it only apply if the company is in California?
That's the kicker. No, it has what's called extraterritorial reach. It applies to any company that does business in California and meets certain thresholds, like revenue or amount of data processed, regardless of where that company is physically located. Yeah. So a company in Texas or New York or even Europe has to comply with CCPA if they handle data of California residents. It's had a huge ripple effect.
Wow. Okay, so the U.S. is patchy, state-led. How does Europe compare? You mentioned GDPR.
Europe's approach is much more unified and, frankly, much stricter with the General Data Protection Regulation, or GDPR. It came into force in 2018, and it's widely considered the most important piece of privacy legislation in the world right now.
Why is it so significant?
Several reasons. First, like CCPA, it has global impact. It applies to any company anywhere in the world that processes the personal information of EU citizens. So U.S. companies serving European customers absolutely have to comply.
Okay. Global reach. What rights does it give people?
It significantly strengthens individual rights. EU citizens have the right to access all their personal info held by a company, usually free of charge, within 1 month. They have that powerful right of erasure, the right to be forgotten, compelling companies to delete their data under certain conditions. It also ensures data portability, the right to take your data with you if you switch services. And, crucially, it gives individuals the right to sue companies directly for damages if their privacy rights are violated.
So strong rights for individuals. What about the companies? What do they have to do?
The responsibilities for organizations under GDPR are pretty stringent. Many need to appoint a data protection officer, DPO. They must get explicit, positive, opt-in consent for data processing. No pre-checked boxes allowed. They need a clear legal rationale for why they're collecting data and how long they'll keep it. They have to report data breaches to authorities, usually within 72 hours. And they need to implement privacy by design and privacy by default in all their systems and processes.
Privacy built in from the start.
Exactly. Plus, there are limits on using data for targeting individuals. It often needs to be anonymized or aggregated at an audience level, and the penalties for noncompliance are severe. Fines can go up to 20 million euros or 4% of the company's total worldwide annual revenue, whichever is higher.
4% of global revenue, that's huge.
It's massive. It definitely got the attention of boardrooms worldwide. And to manage data transfers outside the EU, like to the US, they have mechanisms like privacy shield agreements, though those have faced legal challenges, to try and ensure equivalent data protection standards are met. It really sets a high bar globally.
Okay, so laws are one piece. What about the industry itself? Do they try to regulate themselves? And what about technology? Can tech itself help protect privacy?
Yeah, there's always a debate about industry self-regulation. You see things like voluntary codes of conduct, privacy seal programs, like trustee seals you might see on websites. The effectiveness is, well, debatable. Critics argue it's often too weak, lacks real enforcement, and can be more about PR than substantive protection.
The fox guarding the henhouse argument.
Sometimes, yeah. But technology is also stepping up to offer solutions, which is encouraging. Laudon and Traver list quite a few in Table 8.9. Think about Apple's App Tracking Transparency, ATT feature.
Right, the pop-up asking if you want the app to track you.
Exactly. That simple pop-up requires apps to get your explicit permission before tracking your activity across other companies' apps and websites. That was a big move.
Definitely noticed that. What else?
There's differential privacy software. Companies like Apple use this technique to analyze user data in aggregate ways while adding noise or randomness, making it much harder to link specific data points back to any single individual. Reduces the risk of de-anonymization.
Okay, smart math stuff.
Pretty much. We're also seeing the rise of privacy-focused browsers by default. Browsers like Epic, Brave, DuckDuckGo are designed specifically to block tracking cookies, prevent IP address tracking, and limit fingerprinting right out of the box.
So you don't have to fiddle with settings as much.
Right. For secure communication, you have message encryption tools like Signal or Proton Mail, offering end-to-end encryption. And to fight off unwanted software, there are spyware blockers and ad blockers that detect and remove malware or just stop your browser from even calling out to ad servers in the first place.
Ad blockers are popular.
Very. For even more anonymity, there are things like anonymous remailers for email or anonymous surfing tools like the Tor browser, which routes your traffic through multiple servers to obscure your origin. And of course, the more traditional tools like browser settings to block or manage cookies, and using public key encryption to secure files or emails yourself.
So quite a toolbox is developing on the tech side, too.
It is. It's an ongoing evolution on both the legal and technological fronts.
So for the students listening, especially those thinking about creating and operating an electronically based business that's core to the course description, right? The takeaway seems clear. Building strong privacy protection into your design from the start. It's not just like a nice ethical thing to do. It's becoming a competitive advantage and, frankly, a legal necessity, especially if you want to operate globally.
Couldn't agree more.
And choosing the right hardware and software solutions to actually protect user data effectively. That's a critical skill you need to develop, tying directly into those course skills outcomes. You have to know how to implement this stuff.
Okay, let's shift gears slightly. We've talked about personal data privacy, but what about protecting the things people create online? This brings us to our next big area. Intellectual property rights, protecting creation in the digital age.
Right, IP, another huge topic.
Huge. And at its core, intellectual property, or IP, refers to those intangible creations of the human mind. Things like inventions, literary and artistic works, designs, symbols, names, images used in commerce.
Things you can't physically hold but have value.
Exactly. They have immense value. And the main purpose of IP law, why we have these laws, is to encourage the creation of a wide variety of these intellectual goods. How does it do that? By giving creators certain limited property rights over their creations for a period of time.
Okay, so it's an incentive.
It's a direct economic incentive. If you innovate, if you create something new and useful or expressive, we'll give you a temporary monopoly so you could potentially profit from it and recoup your investment. That's the basic deal.
Now, you mentioned IP is different from physical property. There's this indivisible nature aspect. Can you unpack that a bit and why it makes protecting IP so uniquely challenging, especially online?
That's a great question. Think about it like this. If I have a physical object, say an apple, and I eat it, you can't eat the same apple, it's gone. Physical property is rivalrous consumption by one person prevents consumption by another.
Right, one apple, one eater.
But intellectual property is different. If I listen to a song or read a digital book or use a piece of software, that doesn't stop you or a million other people from doing the exact same thing simultaneously. The good itself isn't depleted. It's non-rivalrous.
Okay. Unlimited people can consume it without using it up.
Precisely. And that unique characteristic is why IP protection is so crucial, especially in the digital age, where copying is essentially free and instantaneous. It leads to what economists call the appropriation problem or the free rider problem. It's incredibly easy for someone to copy and distribute your creation without your permission, potentially at a lower price because they didn't bear the costs of creation, thereby undermining your ability to profit from your work.
So IP law tries to fix that market failure.
It tries to fix that market failure, but it's always a delicate balancing act. The law needs to be strong enough to provide that incentive to create, but not so strong that it unreasonably restricts the public's ability to access, use, and build upon existing works. You don't want IP law to stifle follow-on innovation or free expression.
Finding that sweet spot.
Finding that very difficult sweet spot and understanding these different IP models and the trade-offs involved is crucial for you as e-business students, not just for evaluating others' business models, but for protecting your own innovations, your own website designs, your software, your branding, when you build your e-commerce projects.
Okay, so how do we actually protect these intangible creations? What are the main legal tools?
There are three main types of intellectual property protection you'll encounter most often, especially online. First, there's copyright law.
Copyright, we hear that a lot.
Yeah. Copyright protects original forms of expression that are fixed in a tangible medium. Think literary works, books, articles, website text, artistic works, photos, graphics, videos, musical compositions, the notes and lyrics, and importantly for us, computer code.
Software code is copyrighted.
Yes, the literal code is considered a literary work and is protected by copyright. The key thing about copyright is that it protects the expression of an idea, not the underlying idea itself. And the protection lasts for a long time, generally the life of the author, plus 70 years, or longer for corporate works.
Okay, expression, not the idea. What's the second type?
Second, we have patent law. Patents grant the owner an exclusive monopoly, but on the ideas behind an invention, the functionality, the process. This protection is shorter than copyright, typically 20 years from the filing date.
So patents protect how it works?
Exactly. Patents cover things like machines, manufactured products, chemical compositions, and importantly, methods or processes, including, controversially sometimes, business methods implemented via software. Unlike copyright, patents do protect the underlying inventive concept.
Okay. Copyright for expression, patents for invention. Third type.
Third is trademark law. Trademarks protect words, names, symbols, logos, sounds, even colors that are used to identify and distinguish the goods or services of one party from those of others. Think brand names, logos.
Like the Nike swoosh or the name Coca-Cola.
Precisely. The main goal of trademark law is twofold. Protect consumers from confusion about the source of goods or services, and protect the business owner's investment in their brand reputation from piracy or misappropriation.
Got it. Copyright, patent, trademark. Are there others?
There are other forms, yeah. Things like trade secrets, like the Coke formula kept confidential, industrial design rights, protecting the ornamental look of a product, plant variety rights, trade dress, the overall look and feel of a product or packaging. But for most e-commerce situations, copyright, patents, and trademarks are the big three you really need to understand.
Okay, let's dig deeper into copyright then, because so much online content falls under it. You mentioned it protects expression, not ideas. And there's this important exception called fair use.
Yes, the doctrine of fair use is absolutely critical, especially in the U.S. context. It's essentially a set of limitations and exceptions built into copyright law. It permits the limited use of copyrighted material without needing to get permission from the copyright holder.
Why have an exception like that? Doesn't it undermine copyright?
That's the balancing act again. The purpose of fair use is to balance the legitimate interests of copyright holders with the equally important public interest in the wider distribution and use of creative works. It prevents copyright from becoming a tool that stifles criticism, commentary, news reporting, teaching, scholarship, research, parody, all things vital for a healthy culture and the progress of knowledge. It ensures copyright promotes, rather than hinders, creativity.
Okay, so it's a safety valve. How do you know if something is fair use? Is there a clear checklist?
If only it were that simple. No, fair use is notoriously fuzzy. It's not a clear, bright-line rule. It's determined on a case-by-case basis by weighing 4 specific factors, which are actually codified in the U.S. Copyright Act, Section 107.
Okay, what are the 4 factors?
Factor 1 is the purpose and character of the use. This looks at why and how you're using the copyrighted work. Is it for commercial gain, or is it for nonprofit educational purposes?
Yeah.
And crucially, is the use transformative?
Transformative, what does that mean?
Transformative use means you've added something new, with a further purpose or different character, altering the original work with new expression, meaning, or message. You're not just copying it, you're building on it or commenting on it in some way. Parody is a classic example of transformative use.
Okay, like Weird Al Yankovic songs?
Exactly. Or take the case Campbell via Cuff Rose music. The rap group 2 Live Crew made a parody of Roy Orbison's song, Oh Pretty Woman. The Supreme Court said even though it was commercial, it was transformative because it commented on and ridiculed the original. That weighed heavily in favor of fair use.
But not all reuse is transformative.
Definitely not. There was another case, Andy Warhol Foundation v. Goldsmith. Warhol had created silkscreen prints based on a photograph of the musician Prince. The court recently ruled that Warhol's use wasn't transformative enough because it didn't add sufficient new meaning or message. It was still recognizably Goldsmith's photo, just in Warhol style, and served a similar commercial purpose, licensing as a magazine cover. So transformativeness is key, but it's judged case by case.
Okay, factor 1. Purpose and character, especially transformativeness. Factor 2.
Factor 2 is the nature of the copyrighted work itself. Is the original work highly creative, like a novel or song, or more factual, like a news article or technical manual? Fair use is generally broader for factual works than for highly creative ones. Also, is the work published or unpublished? Unpublished works traditionally get stronger protection, though that's less decisive now than it used to be.
Okay, nature of the work. Factor 3.
Factor 3 is the amount and substantiality of the portion used in relation to the copyrighted work as a whole. Basically, how much did you copy? Generally, using a smaller amount is more likely to be fair use than using a large portion or the entire work.
Less is more, usually.
Usually. But it's not just about quantity, it's also about quality. Even copying a very small amount can weigh against fair use if it's considered the heart of the work, the most memorable or critical part. That came up in the Harper Row case involving President Ford's memoirs. Quoting just 300 words was deemed not fair use because they were the most significant part.
Ah, so even a little bit can be too much if it's the core part.
Right. Although copying an entire work can sometimes be fair use if it's necessary for a transformative purpose. Think about the Sony Betamax case. Recording entire TV shows for later viewing, time shifting, was fair use. Or Google creating thumbnail images of photos for its search engine that involved copying the whole image but was found fair use because the purpose was transformative, indexing.
Okay, amount and substantiality. And the final factor.
Factor 4, and often considered the most important factor by courts, is the effect of the use upon the potential market for or value of the copyrighted work.
Does your use hurt the original creator's ability to make money?
Essentially, yes. Does your use act as a substitute for the original work? If people are likely to consume your version instead of buying or licensing the original, that weighs heavily against fair use. However, courts also recognize that some uses, like critical reviews or parodies, might harm the market for the original simply because they're critical or mocking, but that kind of harm doesn't count against fair use.
So market harm from substitution is bad, but harm from criticism is okay.
Generally, yes. And sometimes a use might even help the market. Remember the Google Books case. Google scanned millions of copyrighted books to create a searchable database. Publishers sued. But the courts ultimately found it was transformative fair use, partly because making books discoverable through search could actually increase sales, not substitute for them.
Wow. That's counterintuitive, but makes sense. So courts are weighing these 4 factors together.
Exactly. No single factor is decisive. They all have to be weighed and balanced in light of the overall purposes of copyright law. And it's important to remember, fair use isn't just a defense you raise after you get sued. The courts have clarified, like in the Lenz v. Universal Music case, the Dancing Baby video with a Prince song, that fair use is an affirmative right, something copyright holders must consider before sending takedown notices.
That's a really important shift, valuing innovation and public benefit more. How does this play out globally? Is fair use a worldwide thing?
Not exactly. The U.S. concept of fair use, with its flexible 4-factor test, is actually quite unique and generally considered broader than the approach in many other countries, particularly those following the British Commonwealth tradition. They tend to have systems of fair dealing.
Fair dealing. Different how?
Fair dealing typically lists specific, closed categories of purposes for which copying is allowed, like research, private study, criticism, review, news reporting. If your use doesn't fit neatly into one of those categories, it's likely not fair dealing, even if it might seem fair under the U.S. factors. It's generally less flexible.
So more rigid exceptions?
More rigid, yeah. Although some countries like Canada have broadened their fair dealing provisions recently. And interestingly, a few countries like Israel, Malaysia, Singapore, and South Korea have actually adopted U.S.-style fair use provisions into their own laws. So it's a bit of a patchwork globally.
Okay, so fair use is complex, especially internationally. Now, all this discussion about copyright, especially online, inevitably leads to the Digital Millennium Copyright Act, or DMCA, from 1998. What was that all about?
The DMCA was the U.S.'s first major attempt to update copyright law for the digital age, dealing with the challenges posed by the internet and digital copying.
What were its main goals?
It had several key provisions. One major part was the anti-circumvention rule. It made it illegal to manufacture, distribute, or even just use technologies, devices, or services that are primarily designed to bypass technological measures like encryption or copy protection schemes that control access to copyrighted works.
So breaking digital locks became illegal.
Basically, yes. Another huge part was creating these safe harbor provisions for online service providers, like ISPs, hosting companies, or platforms like YouTube.
Safe harbor, meaning?
Meaning they generally aren't liable for copyright infringement committed by their users, like someone uploading a copyrighted movie, provided they meet certain requirements. The most famous requirement is that they have to implement a notice and takedown system. They must expeditiously remove or disable access to infringing material when they receive a proper notification from the copyright holder.
Ah, the DMCA takedown notice. We hear about those.
Exactly. That's where they come from. The DMCA also made it easier for copyright owners to subpoena ISPs to identify users suspected of infringement.
So the DMCA was meant to fix things for the internet age. Did it work? Is it controversial?
Oh, highly controversial. Still is. The debate is really about whether it struck the right balance. Did it appropriately balance the rights of copyright owners with the rights of users, including their fair use rights?
What are the arguments?
Critics argue the anti-circumvention rules are too broad and can actually prevent legitimate fair uses, like quoting a snippet from an encrypted ebook for review or archiving old software. They say it chills free speech and innovation. Others, particularly from the content industries, argue the DMCA isn't strong enough to combat widespread online piracy and that the takedown process can be abused by bad actors sending false notices.
So it's still a balancing act problem. How do you ensure fair use can happen if encryption legally blocks access?
That's the million-dollar question, isn't it? It highlights the fundamental tension between technological protection measures and legal rights, like fair use. It's an ongoing challenge for courts and policymakers.
Okay, moving beyond copyright. What about patents in e-commerce?
Patents, remember, protect the ideas behind an invention, giving that 20-year monopoly. In e-commerce, this became really significant and controversial with the rise of business method patents. Companies started patenting ways of doing business online.
Like Amazon's one-click patent.
That's the most famous example. Amazon patented the idea of buying something online with a single mouse click. While intended to incentivize innovation, these kinds of patents can also, arguably, stifle competition by locking up fundamental online processes. Laudon and Traver have a table showing other examples of e-commerce patents, things related to internet advertising, search engines, etc. It raises questions about whether these are truly inventions in the traditional sense.
Yeah, seems like it could block others easily. What about trademarks online?
Trademarks are crucial for branding in e-commerce, just like offline. Protecting your brand name, your logo online is vital. Infringement online can take several forms. There's classic market confusion. Someone uses a mark so similar to yours that consumers are likely to be confused about who's providing the goods or services.
Okay, confusing the customer.
Then there's dilution. This applies mainly to famous marks. It's using a mark in a way that weakens its uniqueness or harms its reputation, even if consumers aren't necessarily confused about the source. Think of someone selling illegal drugs under the name Disney. Disney could sue for dilution.
Tarnishing the brand.
Exactly. And then there's bad faith infringement, where someone uses your mark intentionally, often to try and extort money from you. This leads directly to internet-specific problems like cybersquatting.
Ah, grabbing domain names.
Right. Cybersquatting is registering a domain name that incorporates someone else's trademark in bad faith with the intent to profit from it, maybe by selling the domain back to the trademark owner for a high price or diverting traffic.
And cyber piracy. Similar.
Similar intent, but often focused specifically on diverting traffic to an infringing site, maybe one selling counterfeit goods or malware. Type of squatting is a common technique, registering domains that are slight misspellings of popular brands, hoping to catch users who make typos.
Like Google instead of Google.
Exactly like that.
Yeah.
To combat this, the U.S. passed the Anti-Cyber-Squatting Consumer Protection Act, or ACPA. It creates civil liability, allows trademark owners to sue cybersquatters who register potentially dilutive domain names in bad faith.
So there are tools to fight back. And this whole area is evolving with new tech, right? Like NFTs. You mentioned a case involving Hermes bags.
Yes, that Hermes v. Rothschild case involving Meta Birkin's NFTs is fascinating. It really highlights how traditional IP law is grappling with new digital assets.
Remind us what happened.
An artist, Mason Rothschild, created and sold NFTs, unique digital tokens called Meta Birkins, which depicted furry, stylized versions of Hermes's iconic and very expensive Birkin handbags. Hermes, which hadn't authorized this, sued him for trademark infringement, dilution, and cybersquatting related to the MetaBirkins.com domain.
And what was his defense?
Rothschild argued his Meta-Birkins were artistic expression protected by the First Amendment, similar to how Andy Warhol used Campbell's soup cans in his art. He claimed they were commentary, not counterfeit goods.
So art versus trademark, who won?
Hermes won. The jury found that the Meta-Birkins NFTs were likely to confuse consumers into thinking they were officially associated with Hermes, and that they infringed and diluted Hermes's famous trademark rights. Rothschild was ordered to pay damages.
Wow, so that sets a precedent.
It certainly sends a strong signal that established trademark law does apply in the metaverse and to NFTs, especially when there's a likelihood of confusion or dilution. Brands need to be vigilant about protecting their IP in these new digital spaces, and creators need to be careful about using existing trademarks.
Okay, one more IP type. Trade secrets. What are those?
Trade secrets protect confidential business information that provides competitive edge. It could be a formula, like Coca-Cola's, a manufacturing process, a customer list, a marketing strategy. Basically, any information that derives independent economic value from not being generally known, in which the company takes reasonable efforts to keep secret.
So you don't register it like a patent or a trademark?
No, protection arises automatically from keeping it secret. Trade secrets are protected primarily by state law, although there's now also a federal law, the Defend Trade Secrets Act, DTSA, that provides a federal cause of action for misappropriation. The protection lasts as long as the information remains secret and valuable.
Okay, so secrecy is key. Now, we've talked about the purpose of IP law encouraging innovation. It's not without its critics, right?
Not at all. There are significant criticisms. Some critics, like Richard Stallman of the Free Software Foundation, dislike the very term intellectual property. They prefer terms like intellectual monopoly, or specific terms like copyright, patent, trademark.
Why? What's wrong with intellectual property?
They argue it's misleading because it lumps together very different laws. Copyright, patent, trademark have different rules, histories, justifications under one umbrella. And more importantly, they argue it creates a bias by implicitly comparing these legal monopolies to ownership of physical property, which is fundamentally different because physical property is scarce for rivalrous, while ideas are not. Using the term property, they say, predisposes people to think stronger protection is always better.
Interesting linguistic point. What are the more substantive criticisms?
Critics argue that current IP laws, particularly patents, can sometimes be too broad or granted too easily, and can actually harm innovation and public welfare instead of promoting it.
How so?
Well, think about pharmaceutical patents. While they incentivize drug development, they can also make life-saving medicines incredibly expensive and inaccessible, particularly in developing countries. That raises huge ethical and human rights concerns. Or consider the proliferation of software patents and business method patents. Critics argue these often cover obvious ideas and can be used by large companies or patent trolls to stifle competition and innovation from smaller players.
Patent trolls, companies that just own patents to sue others.
Exactly. They don't make products, they just assert patents. Another concern is patent thickets, dense webs of overlapping patent rights in a particular technology area, like nanotechnology or semiconductors. It can become so complex and expensive to navigate the patent landscape that it actually deters companies from innovating in that field.
So IP laws can sometimes backfire.
They can, if not carefully calibrated. The World Intellectual Property Organization, WIPO, itself acknowledges potential conflicts between IP systems and fundamental human rights, like the right to health, the right to food related to seed patents, the right to culture, the right to access information, and benefit from scientific progress.
And what about culture? Does IP law handle things like traditional knowledge well?
That's another major criticism. Current IP law, with its focus on original, identifiable, individual authors or inventors, often doesn't fit well with protecting collective indigenous knowledge or traditional cultural expressions, which may have evolved over generations within a community. This can lead to concerns about cultural appropriation, where outsiders commercialize traditional knowledge without permission or benefit sharing.
And things like remixes online.
Yeah, IP law often struggles to recognize and accommodate new forms of creativity, like remix culture, where creators sample and transform existing works to create something new. While fair use can sometimes apply, the legal uncertainty can definitely hinder expression for many digital creators.
So for our e-business students who are thinking about security issues for their projects, another skills outcome.
Right, assessing security issues.
The takeaway is that protecting your IP is important, but you also need to understand that the whole system of IP is this really complex balancing act. It has broad societal implications, and the rules are constantly being debated and evolving, especially online. It's not just about locking things down, it's about participating in a system that ideally fosters both innovation and access. #4 Governance and public safety and welfare in e-commerce.
Okay, we've covered individual rights with privacy and creative rights with intellectual property. But who actually makes the rules for this huge global digital space? That brings us to our fourth major section, governance and public safety and welfare in e-commerce.
Hmm.
How is the internet governed, if at all?
That's a massive question, and the answer has really evolved over time. If you look back, you can see distinct phases.
Like stages of internet governance. Kind of, roughly, from the internet's origins in the 1970s up to about 1994, it was largely under government control, particularly U.S. government funding and oversight, as it grew out of military research. ARPANET.
Okay, government-led initially.
Then, from about 1995 to 1998, there was a big push towards privatization. Key functions like domain name registration were handed over to private entities. This coincided with a period starting around 1995 and continuing today, where there's been a strong emphasis on industry self-regulation. The idea was let the industry figure it out.
The hands-off approach.
Right. But almost in parallel, starting around 1998 and definitely accelerating, we've seen a steady resurgence of government regulation trying to address issues that self-regulation wasn't solving, like privacy, security, competition, content moderation. So it's this mix now.
So it's not ungoverned, despite what people used to say.
Definitely not. The early narrative was often the internet is inherently ungovernable, it transcends borders, governments can't control it, but we now know that's largely a myth.
How can it be controlled?
Well, think about the physical infrastructure. The internet relies on network access points, servers, routers, undersea cables, internet service providers, ISPs. Governments can exert control at any of these choke points. They can mandate filtering, surveillance, require ISPs to block certain sites, or demand user data. Access to nearly all internet communications can be monitored and regulated by governments that choose to do so.
So technically controllable, that leads to controlling content, doesn't it?
It does. And efforts to control online content are probably one of the most controversial areas of internet governance.
Yeah, censorship versus free speech debates.
Exactly. A really pivotal piece of U.S. legislation here is Section 230 of the Communications Decency Act, CDA, passed way back in 1996.
Section 230. Hear that a lot, too, usually in heated debates.
Very heated debates. What Section 230 basically says is that online platforms, websites, social media networks, forums generally cannot be held legally liable for the content posted by their users. They're treated as distributors, like a bookstore or newsstand, not as publishers who are responsible for everything they print.
So Facebook isn't responsible if I post something defamatory.
Generally, under Section 230, Facebook wouldn't be liable for your post, though you could still be liable. This protection is widely credited with allowing the internet as we know it, with user-generated content, reviews, social media to flourish. Without it, platforms might have had to pre-screen everything, which would have drastically limited online speech.
But now people want to change it.
There's a huge ongoing debate about whether Section 230 should be repealed or significantly revised. Critics argue it gives platforms a free pass to host harmful content like hate speech, misinformation, harassment, terrorist propaganda without consequence. They want platforms to take more responsibility. Defenders argue that changing Section 230 would stifle free expression, harm smaller platforms, and lead to more censorship as platforms become overly cautious.
Wow. Huge ethical, social, political implications there.
Massive. It perfectly illustrates how difficult it is to create effective laws for these new digital technologies, where the lines between being a neutral platform and an active publisher are constantly blurring.
Okay, another big governance issue, money. Specifically, taxing online purchases. That's changed a lot, hasn't it?
Oh, dramatically. For a long time, sales made over the internet generally weren't subject to state sales tax unless the seller had a physical presence, like a store or warehouse, in the buyer's state.
Which gave online retailers a big price advantage.
A huge advantage over local brick-and-mortar stores who did have to collect sales tax. States, meanwhile, were losing out on billions in potential revenue as e-commerce exploded.
So they fought back.
They pushed hard for years. It culminated in a landmark 2018 Supreme Court case, South Dakota v. Wayfair. The court overturned the old physical presence rule.
What did they decide?
They ruled that states can require online retailers to collect and remit sales taxes even if they don't have a physical presence in the state, as long as they meet certain thresholds of economic activity, like a certain number of sales or dollar amount of revenue in that state.
So no more tax-free online shopping, basically.
Pretty much, yeah. It leveled the playing field somewhat between online and physical retailers, and critically started funneling significant tax revenue back to state and local governments. Big shift.
Okay. And then there's the perennial debate over net neutrality. Still relevant.
Absolutely still relevant. Net neutrality is the principle that all internet traffic should be treated equally by internet service providers, ISPs, the companies like Comcast, Verizon, AT&T, that provide your internet connection.
Treated equally how?
Meaning they shouldn't block or slow down, throttle, specific websites or services, nor should they create paid fast lanes where some content providers can pay extra to have their traffic delivered faster or more reliably than others. All data packets should travel at the same speed, regardless of origin, destination, or content.
Sounds fair. But it's been controversial.
Highly controversial, with a real regulatory roller coaster.
Yeah.
In 2015, under the Obama administration, the Federal Communications Commission, FCC, classified ISPs as common carriers under Title II of the Communications Act, basically treating them like public utilities.
Like phone companies.
Right. This gave the FCC strong authority to enforce net neutrality rules, prohibiting blocking, throttling, and paid prioritization.
But that didn't last.
No. In 2017, under the Trump administration, a new FCC leadership reversed that decision, repealing the 2015 rules and stripping away the Title II classification. They argued the regulations stifled investment and innovation by ISPs.
So back to less regulation.
At the federal level, yes. However, federal courts later ruled that while the FCC could repeal its own rules, it couldn't legally prohibit states from enacting their own net neutrality laws.
Ah, so the fight moved to the states.
Exactly. California passed a strong net neutrality law, and several other states have followed suit or have legislation pending. So it's become this patchwork again, with different rules potentially applying in different states. The debate continues.
How does this net neutrality fight directly impact, say, an e-business student planning their future venture? Why should they care?
Oh, they should care a lot. The outcome of the net neutrality debate directly impacts the technical and business considerations for creating and operating an electronically based business that's straight from your course description. It fundamentally affects the competitive landscape and your potential access to customers.
How so?
Well, imagine a future without strong net neutrality rules. ISPs could potentially strike deals to favor certain large established streaming services or e-commerce giants, maybe by offering them faster speeds or exempting their traffic from data caps, while smaller startups or competing services get relegated to a slower lane.
Creating an uneven playing field.
Exactly. It can make it much harder and more expensive for new, innovative online businesses to reach customers and compete effectively. Your operating costs could go up if you have to pay for prioritized delivery. Your service quality could suffer if you can't afford it. It could stifle innovation.
And what about those different pricing mechanisms mentioned? Tap pricing, usage billing, highway pricing?
Right, those are different ways ISPs might try to manage bandwidth and potentially monetize traffic if net neutrality isn't enforced. Tap pricing or speed tiers is common. Now you pay more for faster download-upload speeds. Usage-based billing or congestion pricing means you pay based on how much data you consume, or maybe pay higher rates during peak hours. Highway toll pricing is the most controversial in the net neutrality context. That's the idea of charging content providers like Netflix or maybe your future startup a fee to ensure their traffic reaches end users reliably, essentially a toll for using the ISP's network.
So as a future e-business owner, you need to understand how these potential shifts could affect your costs, your user experience, your whole business model.
Absolutely. It's a fundamental infrastructure issue that underpins the entire digital economy.
Okay, shifting from governance structure to more direct impacts on people, public safety and welfare in the digital sphere. A big concern has always been protecting children online.
Yes, a long-standing and difficult challenge. We've seen various legislative attempts over the years. There was the Communications Decency Act, CDA, back in '96, parts of which were struck down as unconstitutional, but Section 230 survived. There was also the Children's Internet Protection Act, CIPA, which requires schools and libraries receiving federal funds to use internet filters to block obscene or harmful content for minors.
And COPA, which we talked about for privacy.
And COPA, yes, focused on data collection from under 13s. The challenge with content filtering, though, is always the First Amendment. Efforts to broadly ban certain types of content often run into free speech concerns. Plus, defining what constitutes legally obscene or harmful to minors is notoriously difficult and subjective.
The blurry lines again.
Always the blurry lines. And technology often outpaces the laws anyway.
What about things like illegal goods or services online? Gambling, drugs, cigarettes. How does e-commerce deal with borders there?
That brings up the question Laudon and Traver pose. Is the web really borderless? When it comes to things like online gambling, illegal in many U.S. states, selling prescription drugs without a prescription, or even selling cigarettes across state lines with differing tax laws, the answer is clearly no. Borders still matter legally.
So how do businesses operate in those gray areas?
Often, they try to evade jurisdiction by operating from offshore locations, countries with looser regulations, like Antigua or Costa Rica for online gambling sites, for example. It becomes a constant game of cat and mouse between businesses trying to skirt regulations and authorities trying to enforce them across borders.
And looking ahead, what about emerging technologies, the metaverse? Laudon and Traver have an Insight on Society piece asking, immersed in the metaverse, will it be safe?
Yeah, that's diving into the next frontier. As we spend more time in these immersive virtual environments, what new health and safety issues arise? We're talking potential psychological effects, addiction risks, new forms of virtual harassment or assault, maybe even physical safety issues related to VR hardware.
Wow, that sounds like a whole new set of ethical dilemmas for the companies building these spaces. How do they balance pushing the boundaries of innovation with ensuring user well-being in a world that, frankly, barely exists yet?
It's an enormous challenge. Will the industry be able to effectively regulate itself in these nascent spaces? Or will we need entirely new laws and policies specifically designed for the metaverse? We just don't know yet. It's unfolding right now.
And governments aren't just reacting, they're actively using technology for public safety too, right? Smart cities.
Yes, absolutely. The whole concept of the smart city involves using technology, sensors, networks, data analytics to manage city resources and services more efficiently. And a big part of that is often public safety.
Like CCTV cameras everywhere.
That's part of it, yeah. Increased surveillance through CCTV is common, but it's going beyond that, especially as cities face growing populations and sometimes strained police resources. They're turning to drones, sophisticated analytics, and even robots.
Robots for policing.
Robots are increasingly seen as valuable tools, particularly for tasks that are dangerous for human officers dealing with suspected bombs, entering hazardous environments, responding to active shooter situations. They can decrease officer exposure to harm and access hard-to-reach areas.
Are there actual examples of this being used now?
Oh yeah. The NYPD, for instance, controversially deployed DigiDog, a four-legged robot developed by Boston Dynamics for patrol in places like Times Square and subway stations. It's equipped with LiDAR for navigation, cameras, GPS, speakers, microphones, though it's always supposed to be under human oversight.
Controversial, I bet. What else?
In South Korea, Seoul has used a robot called Goalie for night patrols. It's designed to detect potential dangers like violence or fires, using AI analysis of video and sound, alert people through its speakers, and communicate with a control center. It even has thermal imaging. Interestingly, current regulations there require a human to accompany it, and its video can't be stored due to privacy laws.
Privacy laws limiting the robots. Interesting.
Yeah. In Portland, Oregon, a security robot named Rob patrols parking garages. It has cameras, speakers, and intercom, can read license plates, detect heat signatures, and even identify individuals who are banned from the property. And Singapore has deployed Xavier robots to patrol public areas and deter undesirable social behavior, like illegal smoking or improperly parked bicycles, sending real-time alerts back to a command center.
Wow. RoboCop doesn't seem so far-fetched anymore.
It's definitely moving in that direction.
Sure.
But these innovations obviously raise huge ethical questions.
Right.
Like the balance between public safety and privacy. How much surveillance is too much? Who controls the data these robots collect? How is it stored? How secure is it? What about algorithmic bias in how robots detect danger or undesirable behavior?
Right. If AI is biased.
The robot's actions could be biased too. It also raises fundamental questions about human interaction with AI and robotics in positions of authority.
Yeah.
And it connects to the broader, urgent discussions happening now around developing ethical AI governance frameworks to guide the deployment of these powerful technologies responsibly.
So for our e-business students, even if they aren't building police robots.
Right. Even if you're just building an e-commerce site, these developments matter. They highlight that any technology solution you propose or implement needs to be assessed not just for its business value, but also for its potential legal, ethical, social, and political impacts on society. That's a core skill you need evaluating how your tech intersects with the real world. Hashtag tag tag outro.
Wow, okay, what a deep dive that was. We really covered a lot of ground, didn't we, into this just
Oh,
intricate web of ethical, social, and political issues tangled up with e-commerce.
it's a complex landscape.
For sure, it really is. We started out asking, is our digital footprint a threat? Or just the cost of convenience?
Yeah.
And it's so clear the answer is incredibly nuanced. It's shifting all the time.
Not a simple yes or no.
Not at all. From those foundational principles, responsibility, accountability to the constant evolving battle for our information privacy, the complexities around protecting intellectual property online, the huge questions about who governs this digital world. Every single aspect of e-business is basically engineered with moral choices embedded in it.
Every design choice has an ethical dimension.
It really does. Whether we're talking about the right to be forgotten over in Europe or that careful dance of fair use for creators trying to build on existing work or even those, vigilant robotic patrols in smart cities. These aren't just technical details. They're the human-centric challenges that are defining our digital economy.
They shape our experience online and offline.
Absolutely. So for our BCIS 5300789 students listening, remember, understanding and being able to evaluate these legal, ethical, social, political issues, it's absolutely crucial. It's not extra. It's core.
It's what sets responsible professionals apart.
Exactly. It'll empower you to develop e-business solutions and proposals that are not just functional or profitable, but also robust and responsible. That's what will truly set you apart in your careers. So, if you enjoyed this deep dive, if you found it valuable, please do like this episode, subscribe for more insights like this, and maybe share it with your classmates and colleagues who might also benefit.
Don't forget those extra resources.
Right. Don't forget to check the description below for those additional resources that can help you go even deeper into mastering e-business.
Okay, so as we wrap up, here's something to think about. In a world that's increasingly shaped by algorithms, by automation, where does human responsibility truly begin and where does it end for the systems we build and deploy?
That's a heavy one.
It is. How do we make sure that all the convenience and power of e-commerce doesn't come at the cost of our fundamental rights, our privacy, our societal values?
Big questions to keep pondering.
Definitely. Every transaction, every connection, every innovation, it all starts with someone who understands the system behind the screen. Until next time, stay curious, stay strategic, and keep turning complexity into opportunity.